Hello, everyone. Greetings from cold and snowy Milwaukee, Wisconsin. I am Eric Eisenman. I'm a partner here at Husch Blackwell in the Technology, Manufacturing, and Transportation team. I am a labor and employment lawyer, and one of the issues that I work on is advising employers dealing with various workplace counseling issues, including finding the right balance between workplace technology and employee privacy, which is the topic of our webinar today. We're excited to give the presentation today, and we're going to cover, in general, various state and federal laws that impact employee privacy, particularly as it applies to use of technology in the workplace. We'll offer some examples of those laws, some ways that employers can get into trouble as they find ways to use technology to stay abreast and monitor employees, and provide some recommendations and best practices. Before we begin the substantive part of our presentation, I'd like to cover just a few housekeeping items. At the bottom of your audience console, the screen that you're looking at, are multiple application icons that you can use during the program today. I'll highlight several of those. If you have any questions during our webcast today, you can submit those questions to your presenters here via the question box. We will be monitoring that on an ongoing basis during the presentation. If we have time at the end of the hour, we will try to address some or all of those. But if we run out of time, Laura and I will be sure to follow up and provide you with answers to questions that might come up as we go through. We appreciate audience participation and would encourage you to submit those questions. There is an icon on your screen that should assist with your viewing preferences. You can expand the slide area that you see on the screen by maximizing the icon on the top right of that slide or dragging the bottom right corner of the slide area, so you can make that as big as you need to. If you have any technical difficulty during the presentation today, there is a help icon that you can click on. It has a question mark and it provides information regarding common technical issues. A copy of the slide deck that we're using today is available on the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. To report your hours in Illinois, Nebraska, Tennessee, or Texas, just click on the CLE widget at the bottom of your screen and complete the questions. You will need your bar numbers to submit that. You'll want to make sure to do that before the webcast concludes. In addition, our program today has been approved for HR Certification Institute and Society for Human Resource Management recertification credit. A recording of this webcast will be available tomorrow for you to watch and share. Once that is available, a link to the recording will be emailed to you along with a certificate of attendance. Joining me today with the presentation is my colleague Laura Ferrari. Laura is also an attorney here in the Milwaukee office of Husch Blackwell. She practices in the area of labor and employment law, assisting clients with both compliance and regulatory, as well as litigation matters. With that general background out of the way, we will go ahead and get started. Again, just to give you a little bit of an overview where we're going to head today, we will start talking a bit about federal and state law that applies to employee privacy. We'll then segue into some discussion of what employees are doing outside the workplace and what you can do as an employer to monitor that. We'll touch on different ways that employers currently monitor employees and which of those might prove problematic as we see some additional legal development in this area. We'll touch on email, GPS-enabled devices, and some of the emerging Big Brother technology that you read about in the newspaper. I'll spend a bit of time talking about the Illinois Biometric Information Privacy Act. This is a piece of legislation, again, that applies only in Illinois right now, but we believe it's an example of a direction that the law in this area is heading and can provide a useful roadmap for employers as we think about the considerations that we're going to need to review as we move forward. We'll touch a little bit on wellness plans and the privacy considerations there. And then finally, share, again, some key takeaways and best practices for you to consider as you move forward. To begin, as we move into some of the discussion of the federal and state law here, I'm going to turn it over to Laura.
Thank you, Eric. Good morning, everybody. So I'd like to lay some foundation here for some of the laws that impact employers in this area. These are constantly changing, and I want to highlight, first of all, that while federal law is important, state law really governs quite a bit of this as well. So be sure to check your state's law with respect to a lot of these issues. So first of all, we got the Electronic Communications Privacy Act. This act was passed in the 80s as an update to the Federal Wiretap Act of 1968, which was originally, in its first iteration, addressed the inception of communications and telephone lines throughout the World War I era. Now, the more recent version reflects an amendment that includes provisions for the interception of wire, oral, or electronic communications. And like I said, these are constantly being updated. So this one has been updated through the Patriot Act, Department of Homeland Security Act, and amendments through the Foreign Intelligence and Surveillance Act. Now, earlier, these laws were focused primarily on Fourth Amendment issues and government actions and were based primarily in property rights, where a violation or lack thereof was entirely premised upon whether there was a physical trespass. So, for example, if you lived in a townhome and the police wanted to record your conversation, they could use your adjoining neighbor's home to listen in through the shared wall. Now, obviously, this produced some bizarrely technical results, and the analysis then began to shift to whether the individual that's subject to those recordings could reasonably expect the communication at issue would be private. You'll hear this throughout the presentation, this idea of reasonable expectation of privacy. So that becomes pretty important going forward. Under the Act, it's illegal for any person to endeavor to intercept, or procure any person to intercept any wire, oral, or electronic communications. Person, as it's important in this case, includes both the United States and its employees, but also any individual, partnership, association, trust, or corporation. So it does imply to individuals and to employers. Now, wire, oral, and electronic are all defined terms within the statute, but generally these terms mean telephone, face-to-face conversations, and computer communications, respectively. So, for example, this particular act doesn't cover silent video recordings. There are a handful of exceptions to this act, although they're a bit narrow, and this first one applies only if it's not being used for a tortious or criminal purpose. But if the person is a party to the communication, him or herself, or one of the parties to that communication has been, their prior consent has been given. There's also a business purpose exception, whereby if employers monitor these communications in the ordinary course of business, and this communications interception is done via a certain type of device, there is an exception. However, a lot of courts require the employer to establish a legitimate business purpose before monitoring these employees' communications, if it is to rely solely on this communication. And like I said, this can be interpreted narrowly, so proceed with caution with this one. Employee consent is always the better way to go to be on the safe side.
So the key point that I'll just reinforce there is, as Laura said, we've got this overarching federal law, which by its terms would appear to apply to some of the electronic monitoring that an employer might want to do in the workplace. But as you pointed out, an employer can typically fall under one of these exceptions. And this, again, doesn't mean that you're scot-free. You're still going to have to analyze what state law and some of the other things that we talk about here are. But the key there, as Laura just mentioned, is if we're going to be conducting monitoring, the best place to always be is to have an explicit authorization by employees acknowledging that the employer has the right to monitor those sort of communications. If you have that written authorization, then you have the strongest argument to falling into one of these exceptions.
And that's a good point, again, on these themes that are going to be running through the presentation. Employee consent, employee notice, and business purpose. Again, that's going to be important for a lot of these particular laws and regulations. And not only with the Electronic Privacy Act, it contains provisions regarding the use and disclosure of this information as well. So it's not just the capture of it, but it's also the use and disclosure. Part of this act is the Stored Communications Act, which is not its own separate law, but it's distinct in that it provides additional updates on the law in light of the ubiquitous use of the internet. Nowadays, sort of clandestine access to communications that are, quote, at rest, so email, voicemail, social media accounts, cloud-based storage, things that aren't going on sort of live like a person-to-person communication or telephone communication is doing. These things are just as much of a threat to privacy as the interception of telephone communications or oral communications that existed before the internet. So both for the interception and access of communications under the Electronic Communications Privacy Act and the Stored Communications Act, it's important to highlight that the intentional interception or access, respectively, is a required element of the violation. So in other words, the statute makes it a violation to engage in these actions with the purpose or the objective of impermissibly intercepting these access to these communications. So for the Stored Communications Act, it's a crime to intentionally access without authorization a facility through which an electronic communication service is provided, or to exceed an authorization to that access facility. And then thereby obtains, alters, or prevents authorized access to the wire communication while it's in electronic storage in that system. So much of the inquiry with respect to this law occurs when the individual was granted access, but that access was for a different purpose than what the person eventually used it for. So you see this sometimes when an employee is given access to a system to do X, Y, and Z tasks, but actually does, A, B, C tasks. That can also fall under this law. And electronic storage also includes temporary, intermediate, and backup storage, so it covers all of these types of storages that we commonly see used today.
Another federal statute that applies in this context that may not be quite as intuitive in here is the National Labor Relations Act. Obviously, the NLRA is not a privacy statute, but it has implications in this area. You may know that the National Labor Relations Act applies to most workforces, even if you are not a unionized employer. The Act applies in the non-union context as well, at least certain provisions of it. So a section in the Act, and we'll be talking about it a little bit more specifically a bit later, provides employees the right to self-organization and engage in concerted activities for the purpose of collective bargaining or other mutual aid or protection. And there is a violation of the Act, a violation of Section 7 of that Act, if an employer, quote, interferes with, restrains, or coerces employees in the exercise of those rights. Employer monitoring, particularly employer monitoring without the consent or acknowledgement by employees, could be viewed as a violation of Section 7, an unfair labor practice, to the extent the employee would characterize that as monitoring to interfere with their right to engage in the protected activity under the Act. So to the extent the employee tries to spin the monitoring that the employer might be doing as checking up on a discussion of wages, benefits, working conditions, that's where you might get into trouble here under the NLRA if the employee tries to characterize that, again, as interfering with their rights under the Act.
So in addition to these federal laws, like I said, there's also some state laws that are going to be applying in this particular area. The biggest one is common law privacy, which varies by state. And a lot of these laws aren't actual written statutes, but they have developed through common law through the courts. And again, each state's going to be slightly different how it deals with these certain things, what sort of proof needs to be set forth in order to assert a claim for these. But one of the biggest ones is intrusion upon seclusion. And that occurs generally, again, this varies by state, but when there's an intentional intrusion on the privacy of another, and that intrusion would be highly offensive to a reasonable person. There's also the public disclosure of private facts. It's also called publicity to private life, I think, in some states. And this is not so much a concern for employers for monitoring purposes, but could be an issue given the information that employers have access to. So the second one, this publication of private facts, applies when a person publicizes facts that would be highly offensive to a reasonable person, and that's not of legitimate public concern. So again, that exception sort of falls in, the First Amendment with freedom of the press. But for someone who publicizes a private fact about somebody and that fact is highly offensive, that could be a violation of the state common law privacy laws. The other one, like I mentioned before, the Electronic Communications Privacy Act, there is the, not an exception, but if one party to that communication consents, or if you yourself are a party to that communication and you are the one doing the recording, then you're okay under the federal law. However, state laws differ. There are two general umbrellas of state law, the one-party consent state and all-party consent state. So there are a number of states that, like federal law, will exempt the one-party communication. So if only one party, let's say you, the employer, are talking to your employee, you consent, that's okay. There are some states, California I know is one of them, where all parties to that communication have to be notified that that recording is happening. So for example, that's why if you call a customer service line and you get that notification that your call might be monitored for purposes for training and whatnot, that's to let you know that you're going to be recorded. Again, so there's a lot of states that do require that all parties to these communications be notified and consent to the fact that they're going to be recorded.
The interesting tidbit I always think of when you deal with that one-party versus two-party consent issue was many of you will recall during the late 90s, during the Clinton administration, when Linda Tripp was recording her conversations with Monica Lewinsky. She was engaging in some of that activity in Maryland, which is a two-party consent state, and where it would have been illegal for her to do so without the consent of Ms. Lewinsky. But in the District of Columbia or Virginia, which are one-party consent states, she would have been permitted to do that. So again, just an interesting tidbit and something that, again, as Laura said off the top, be sure to make sure you're up to date on what your state law is when you find yourself wading into that area. So we've talked a little bit about the framework here of the laws that might apply. And before we jump into some of the discussion of what employees are doing outside the workplace, we have our first poll question. Our question for you is, are employers permitted to discipline employees for content that they post online that casts the company in or other employees in a negative light? And again, I read that slightly differently. It's a true-false question. The statement is, employers can discipline employees for content they post online that casts the company or other employees in a negative light. True or false? We'll give you a moment to enter your answers. Interestingly, we have a little bit of a split decision. 61% true, 38% false. That is actually a good answer to the question because the correct answer is it depends. I mentioned Section 7 of the National Labor Relations Act before, and that's one of the laws that comes into play here. In some instances, commentary that an employee might post in social media that is critical of the company or critical of coworkers could be characterized as this protected concerted activity. And if an employer takes action against an employee and the employee can successfully make a threshold showing that it was, again, this concerted activity, it would be illegal under the NLRA for the employer to discipline or discharge that employee. Conversely, there are classes of commentary an employee could place if it's, offensive comments about a coworker or commentary that crosses the line and involves profanity or other intentional or tortious statements. An employer will have the ability to take appropriate action. But as we can see from the poll results here, that's not always as clear as we hope it would be. So we'll talk a little bit here next about what are those different things that employees might be doing outside the workplace and whether you, as the employer, have the ability to either monitor or to take action based on that. So to start out with, let's talk a little bit about social media. In the last, 5 years, 7 years, we find that this is a significant issue that our clients are asking us about. And I will tell you some of the most interesting cases that we get to work on are ones where the client comes to us and says, hey, we've got an employee who's posting this stuff on their Facebook page or is tweeting stuff about the company or about coworkers? What can we do? There is, again, this Section 7 of the National Labor Relations Act, which is a framework that we have to be aware of. And my advice is that to the extent that those comments can be perceived as complaints about working conditions, wages, terms of employment, the employer should be extremely careful about taking any action there. If it's more individualized criticism of a coworker and in the nature of sort of just an interpersonal conflict, then the employer is likely going to have greater latitude. But the threshold question, and the first sort of sub-bullet point that you see here on this slide, is the question of passwords. How do you, as the employer, get access to what employees are posting on social media? Sometimes we learn about that by somebody else in the organization who's Facebook friends or follows one of the employees on Twitter who lets us know, hey, so-and-so is making these posts, and brings them to the attention of our HR. The alternative way would be some employers would say, I want to stay up to date with what my employees are posting. Do I have the right to require employees to give me password access to these different accounts? The states that have addressed that question have pretty categorically held that the answer to that question is no. There are a number of states, including California, Colorado, Illinois, Michigan, and Wisconsin, that have statutes on the book that explicitly prohibit employers from requesting applicants' or employees' social media passwords. So again, even if you live in a jurisdiction, not one of the ones I've listed, and that wasn't an exhaustive list, but even if you live in a jurisdiction where there isn't an explicit law prohibiting this, our strong advice would be that you should not be requesting password information from employees as a condition of employment. Again, if you receive information about posts that the employees make secondhand through a coworker, or if you happen to come across it in whatever other sort of online activity that you engage in, you are permitted to consider that, within the parameters that we'll be discussing here. There still are some limitations on what you can do once you have that information. I mentioned this concept of Section 7 rights under the NLRA. Again, the board considers many different sorts of kinds of blog posts or social media posts to be this protected concerted activity. So that's the primary sort of consideration that we're looking at. When employers come to us with those questions, I often find that what they're thinking about is, well, does the employee have some sort of right of privacy in these statements that they would make? And the answer is probably not. If the employee is making the post in a public or quasi-public forum, that is to say posting it on their Facebook, tweeting something out, even if they're doing it on their own time from their own computer, an employer is permitted to view and access that. It's considered to be a public statement. It's not a privacy issue per se. What you can do with that information, again, is maybe limited by a law like the National Labor Relations Act, but it's not really a privacy consideration in that context. There is some discussion we see in the secondary resources that talk about if these comments or statements are made in the context of a non-public posting, right? So a password-protected blog, for instance, that only receives invitees. There might be a stronger privacy argument in that context. But again, the employee would then have to demonstrate that there was, an way to access that information, limited defined users could access it. That raises an interesting question when we talk about Facebook or Instagram, where you have to sort of accept a friend in order to access information. My contention would still be, to the extent that an employee is making a post on a site like that and is being disseminated more generally, that's something that is not necessarily protected as a privacy consideration. So social media, you as the employer are entitled to consider information that's floating out there on the internet, but you should not be asking for passwords and trying to access that stuff on the back end. How about use of lawful products? Many states here, like our home state of Wisconsin, where Laura and I are sitting, have laws that prohibit employers from discriminating against employees for the use or non-use of lawful products. Again, most of these laws historically were created to prohibit an employer from discriminating against an employee who chose to use alcohol or to smoke. So it was basically said, while you can have these laws in the workplace that say you're not allowed to use these products or be under the influence of the products at work, you're not allowed to say we don't hire smokers or we don't hire folks that consume alcohol. The more interesting question is with the developing area of cannabis, marijuana. What happens if you find yourself in a state like Colorado that has a law that says that an employer can't discriminate against someone for engaging in lawful activity, but lawful activity may not be defined the same way under state or federal law. So the Colorado Supreme, again, the idea here would be what if we find out that an employee in Colorado or California is using marijuana? And maybe if in the instance of Colorado, obviously they're free to do that recreationally, or in California, let's say that they have a medicinal purpose to use that. But we have federal law, which still says that marijuana is a federally registered substance and use is illegal. What does that mean? The Colorado Supreme Court has touched on this issue, and they've held that the use of the word lawful in this context means lawful under both state and federal law. Okay, so even though use of marijuana is legal under California or Colorado state law, because it continues to be illegal under federal law, the Colorado Supreme Court says that an employer, can still take into consideration the use of marijuana in its employment decisions. Another area where this kind of comes up is when an employee might try to argue that use of a substance like marijuana arises as a result of a disability. So there was a federal court in Connecticut that addressed a case that was brought under the Americans with Disabilities Act. And a state statute there that protects employees from discrimination based on the lawful use of medical marijuana. So the applicant there told the employer before her pre-employment drug test that she had used a synthetic form of marijuana in the evenings to treat what she described as post-traumatic stress syndrome. After testing positive for cannabis, the employer rescinded that job offer. She sues under the ADA. Say, I have a disability, and you're discriminating against me under the ADA and under this state statute. The court in that case declined to dismiss the case, i.e. it made an initial finding in favor of the employee, holding that the federal law in that case against marijuana does not override the state's anti-discrimination law. So what's my takeaway here? I think the takeaway here is that, we probably need to consider each one of those situations on a case-by-case basis as the law in your state evolves. My editorial comment is I suspect in 10 or 20 years we will see marijuana become, deregulated or come off the restricted substance list on a federal level, and there may be a more uniform system state by state permitting use there, and it will make these analyses more easier to do. But in the interim period, when we've got a sort of this patchwork, you're going to need to make sure you're aware of what your state law is, and before you would take action based on someone's use of a product like that, consult with your friendly legal counsel. Another area where we might be interested in what employees are doing outside the workplace is political activities. So today, maybe more than ever, some employers find these issues coming up in the workplace and are asking, what they're allowed to do, if anything, with the political activities or the political positions of their employees. A number of states currently prohibit employers from retaliating against employees for participating in political activities based on their political affiliation. So again, there's some states, Colorado as an example, that says an employer is not allowed to prevent any of his employees from engaging or participating in politics or from becoming a candidate for public office. But here's the important takeaway on the political activities piece, is in the absence of one of these specific state laws, the First Amendment right to express your opinion or support a political candidate does not extend to the right to have a job. I would say it is a common misperception by employees that I can say anything I want or express my political views in the workplace, and that my employer cannot take action against me on that basis. That's, again, in the absence of one of these laws, actually not true. The First Amendment protects your rights from federal action, certainly, and laws for public employees are different. But for private employees, if an employer doesn't like your political persuasion, they can get rid of you. Now, if I'm the lawyer for the employer, I'm going to advise them to think very carefully before they do that, because the last thing you want is for that employee to then go to the local newspaper and you find your business on the front page, becoming the target of half of the population who either are for or against that position. But as a general rule, the First Amendment does not extend to protecting an individual employee's political statements in the workplace. Some other areas, again, where there are these outside activities that kind of come into play. One of them is firearm ownership. Wisconsin has a concealed carry law now that permits employees to keep firearms in a locked cabinet or in the glove box of their vehicle, even if that vehicle is parked on the employer's parking lot. Some states like Indiana have gone farther. There's a law in Indiana now that prohibits employers from requiring an employee to disclose whether they own or use a firearm or to make an employment decision on that basis. Similarly, there's a North Dakota law that prohibits an employer from discriminating against someone if they have a firearm in their vehicle, as long as they're keeping that safe. This is an area where we've seen some evolution in the law, I would say, over the last 5 years. This, again, falls in that category of, a lawful product or activity. To the extent that you as an employer are considering whether to institute new policies regarding what employees can and can't do in terms of concealed weapons or firearms in the workplace or on the job or in employees' cars, you'll want to consult your local laws about how that would apply. And then the final area that we put in this other category, which is sort of interesting, is reproductive health decisions. So, for example, in the state of Delaware and the District of Columbia, there are laws in place that prohibit an employer from taking employment action against an individual or discriminating against them on any basis in connection with a reproductive health decision that an individual might make. And again, those reproductive health decisions are defined as any decision related to the use or intended use of a particular drug, device, or medical service, including the intended use of contraception, fertility control, or the plan or intended initiation or termination of a pregnancy. An employer is not permitted to discriminate against employees for the use of birth control, not permitted to discriminate against employees on the basis of the employee's decision to, for instance, have an abortion in states or areas like D.C. And Delaware that have laws like this in place. With that, I'm going to pass it back to Laura to talk again about some of our big brother issues, ways in which companies monitor employees.
We've discussed what employers can monitor and view outside the office, but now we're going to talk a little bit about ways that employers monitor employees inside the office. One of the more common ones for on-site surveillance is video surveillance. And like Eric mentioned before, as it applies to the NLRB, there's some concern over there regarding video surveillance or audio surveillance for purposes of collective bargaining or for discussion of wages, benefits, working conditions. So again, want to be careful with that particular issue. But interestingly enough, when it applies to unionized employees, the board has actually held that surveillance is a condition of employment that in some cases has to be a mandatory subject of bargaining. So that's a pretty interesting fact there from the board. And again, regardless of whether they're unionized, employers have to be mindful where the surveillance is occurring so not to run afoul of the NLRA. And it should go without saying, and many states have laws to this effect, but even if your state doesn't have a lot of this effect, this monitoring should not be occurring in places like locker rooms or bathrooms or places where employees should have a reasonable expectation of privacy. And again, there's pretty much no legitimate purpose for example, monitoring employees in the bathroom. The other issue to consider as well is whether you have a obvious visible camera or whether it's more concealed and the employee does not know about it. Now, if you have a visible camera that is near employers where they're working, this is generally considered acceptable because, again, if you see the camera, you probably do not have a reasonable expectation of privacy if that camera is, visible and in your face. However, if it's secret or hidden camera, this should be supported by a legitimate business need because, again, if you're monitoring employees via video surveillance and they don't know about it, there has to be a legitimate business need because, again, they may have an expectation of privacy in some of these areas.
So those are the tougher questions. But in the situation, again, where Laura was saying about sort of the more private areas, we've had clients who say, well, I want to put a surveillance camera in the locker room because we've had reports of theft, right? That's an area where you want to tread really lightly. And if you choose to put the camera there, make sure that you're not getting employee consent because that is an area where there have been a series of decisions that say, in an area where there is an expectation of privacy, having a camera can be very problematic. And as Laura said too, if you want to have a camera that's not obvious, again, the presumption that is that an employee should know that the work area is not a private space. But again, if they have their own office or if they have their own work area, where does that cross the line? It's something that I think the employer wants to think carefully about before just reflectively saying, well, listen, as long as it's in my building, I'm entitled to monitor it.
Exactly. Well, and as it goes to audio recording or surveillance, as we noted before in the Electronic Communications Privacy Act, it provides an exception for monitoring telephone communications if it's done so in the ordinary course of business. And you see this, for example, in telemarketing or customer service positions, or sometimes you see it in the protection of trade secrets, so employers want to make sure that those are being protected. Again, like we discussed before, unless the employer has obtained express consent for unlimited monitoring of business calls, the employer should discontinue recording or listening when the employer becomes aware that the call is personal. There are some employers that I'm sure have prohibitions against using company phones for personal calls, but again, that doesn't give the employer the right to actually listen in on a conversation that is clearly personal. And again, monitoring conversations in non-working areas, so maybe a cafeteria or something along those lines, even amongst employees that have all presumably consented, it can be tricky because, again, if those employees haven't consented and are not aware that they're being recorded, they may, again, in an area like a cafeteria, have an expectation of privacy, and they may, again, talk with their coworkers about their wages or conditions of employment, again, and you don't want to run up against any issues under the National Labor Relations Act. The next one is desk sensors, which, to be honest, I wasn't made aware of until pretty recently, but it's an interesting issue. And from what I understand, it's not so much to monitor employees, but to monitor the effective and efficient use of workspaces. So, for example, Barclays London installed sensors at employee workstations to monitor activity, and the company said that its purpose was to evaluate workspaces, so to cut down maybe on rental space if they didn't need as much space as they were taking. But there's conflicting sort of evidence out there as to whether all employees were notified, and surprisingly, the employees found it rather invasive. So again, if you're going to implement something like this, even if there's no obligation to notify employees, things like this where employees are being monitored, like how long they're at their desks, or when they stand up, or how long they're gone, or how long they're idle, can feel pretty invasive, even if they're aware that they're working for the employer and they should be working. Employees can get a little bit sensitive about this, and then with good reason.
I don't think that I would like to have a desk sensor that tells my bosses when I'm sitting in my chair and when I'm not, even if there was a legitimate reason for it.
Right. So this, like Eric said, gets in a little bit of Big Brother territory, and this is going to be a theme I think we talk about later on. But just because an employer can do it doesn't mean that necessarily should do it. Employee morale must be taken into consideration too. And again, if you are monitoring every move your employee makes as to how long they sit at their desk or how long they are away, it gets a little bit intrusive and invasive. So computers is another one that I'm sure there is a lot of issues regarding monitoring. And luckily for employers, they have generally a wide latitude for monitoring when it comes to their own devices, so their own provided computers or phones during working hours at least. And while state laws can vary on this topic, a common best practices theme is to have a clear written policy regarding computer and internet usage, and that sort of spells out the company's express right to monitor your computer usage, your internet access, and your phones while at work. Now, this isn't a huge consideration, but again, check your state laws for this. So some monitoring may give rise to mandatory reporting. There are a number of states that have state statutes that require IT personnel to report, for example, if they find child pornography on a computer. So if an IT person is servicing some employee's computer and finds that on there, there are states that say that you have to report that. There are also, again, latitudes that employers may want to take that might not be advisable. In one example, an employer had installed a keylogger software, so it's one of those devices or software that tracks what employees are typing. And this employer used that information to gain access to an employee's email and checking account. And obviously that was not a great idea. And the employee's claim, again, it made it past this first stage in litigation under the Stored Communications Act and the state wiretapping statutes. And along with computers, we have email accounts as well. And most companies will provide their employees with email accounts through the company. But again, it's not surprising that I'm sure a lot of employees also periodically check their personal email throughout the day. And again, employees typically don't have a reasonable expectation of privacy in communications via work email, but the Stored Communications Act generally would prohibit employers' access of the employee private email accounts, again, because through those private email accounts, the employees would have that expectation of privacy that if I'm sending emails through my own email account, my employer should not be able to access those.
One of the areas that I see this come up is in situations where we have an employee who departs and maybe we have concerns about that person going to work for a competitor, or that person going out and soliciting clients, or that person using or disclosing our confidential information. Something an employer might choose to do is say, hey, I know that we can go back onto this person's account and we can review what their company email is to see whether they were sending any information to personal addresses or something like that. And that's generally okay. We can go back into their work account to monitor sort of what that was going on. But where you want to be very careful is if we say, well, we actually have, saved in this person's notes folder on Outlook is their password to their Gmail account. Well, we think that they were sending company info to their Gmail account. So we want to know, we want to go in and access that. As Laura said, even if you have the ability to do that, think very carefully about doing that. And this is probably where you'd want to get legal counsel involved to help you figure out what you can and can't do. Ultimately, that sort of communication, again, let's say in this hypothetical the employee was taking our confidential information or soliciting our clients in violation of his or her obligations, and he was doing it through a personal account. If our case ends up in litigation, we're going to be able to access those communications, but we need to do that through a more formalized process. If the employer takes it upon themselves to get that using passwords or whatever that might be stored, if it's a personal account, the employee is going to have a counterclaim against the employer for a breach of privacy under state law or federal law. So you want to be very careful about that.
And that's a great point, and I was going to also set forth an example. This is a case that happened where, again, it was an employee that left and started a competing business, and the employer knew that this employee, or this former employee, had their password and email information sort of auto-logged into the computer and accessed it and tried to use the emails against the former employee. And again, that was not the best idea. Again, and this might sound a bit scary, but depending on the business, some level of monitoring is fine, and it might be beneficial, especially if you're dealing with confidential information or trade secrets, or you're trying to guard against harassment or discrimination that occurred via email or other electronic communications. The next sort of big issue here is GPS-enabled devices, primarily company cars and cell phones. So there are companies, and I read about one of them, that like to have monitoring devices like cameras in their cars because in the event of an accident, they can use that to disclaim liability on behalf of their employee and of the company. And like the case with most things we're talking about, state law is very important. For example, Texas, like a number of other states, have laws that permit employers to monitor GPS systems on company cars and devices, but they require employee consent to monitor employee-owned vehicles. So even if you have an employee that's using his or her own car for work purposes, that is not the same as a company or employer-provided car. Cell phones are pretty similar. Again, most cell phones, if not all, are enabled with GPS capacity. And quite frankly, it's still a pretty murky area, so employers have to be mindful of what information they may uncover, and they should employ a reasonableness test when they're trying to determine whether or not they can monitor and whether these employees have a reasonable expectation of privacy. There was an example, again, this is really quite extreme. I can't believe that this employer did this, but one employer was sued for invasion of privacy by one of their employees for, among other things, allegedly requiring to keep their employees have their cell phones on them at all times and have them on for the purpose of being monitored. Again, this is a really extreme example, but I suspect it was very hard for the employer to justify why it is they needed to be monitoring their employees at 10 o'clock at night when they're off doing personal things or perhaps even sleeping. And again, this isn't a huge concern, but the other thing that employers must take into consideration is what kind of information they're going to be gathering from this GPS monitoring. So again, if you're trying to look at what employees are doing after hours, and they patron an establishment, let's say their after hours may go, for example, to a weekly support group for AIDS, for example. Employers might be tempted to use that information, again, to discriminate against someone, and that could be a violation of the ADA. So that's something that we want to make sure isn't happening. Some examples of some emerging technology, it's getting pretty interesting with technology and employers in the workplace. The first one I want to talk about was these data collection badges. So Deloitte is looking into this. Some of their employees are wearing badges that record the wearer's office behavior, such as movement and frequency of communications during meetings. And I'm not sure where this is going to go in the future, but a lot of this is for efficiency and employee engagement. But again, it seems a bit, at least to me, a bit intrusive. There's another company, and it's a San Francisco startup called Buffer, and it provides its employees with a Jawbone, which is like a Fitbit, and it tracks sleep patterns of their employees. And while this isn't particularly uncommon, a lot of employers can provide their employees with Fitbits or things of that nature. But this particular company, when they provide their Jawbone to their employees, the sleep data is made available to all employees. And apparently, from what I've been reading in these stories, the employees sort of use it to encourage each other to get better sleep, or, oh, hey, I see you're sleeping a lot. What do you do, and how, what can I do to sleep better? The next one is these RFID chips, which came about recently in Wisconsin. There was a company that installed RFID chips about the size of a grain of rice in its employee's finger, and while this has any GPS capacity or anything of that nature, it's used for purchasing things at the employee break room, signing into the printers, accessing employee-only areas. So we're not sure where this technology is going to go, but some states have reacted. For example, Missouri, North Dakota, and Wisconsin now have laws, or did before, that prevent employers from requiring employees to be implanted with this microchip.
That was the story that actually got Laura and I interested in this topic several months ago when we began putting together this presentation. It was one that you all might have read about, and again, it was this Wisconsin company, and it plays to everybody's sort of fears about this state that's going to monitor us wherever we go. And you may recall that a substantial portion of the employee workforce, like a third, I think, agreed to have these chips implanted. They were marketed by the company as, listen, you don't have to carry around your key card to get into the building anymore. You don't have to use a credit card when you buy food from the vending machines. You just sort of hold up your hand. Well, yeah, that's convenient, but how much do you trust your employer to really use that information? So, like Laura said, we're already seeing some states that are implementing laws that prohibit requiring that, and that's the direction this is going to go, right? Like, the law is going to say that an employer is not allowed to microchip an employee the way that you would your golden retriever. But I also think that with some of these examples, again, with some of the startups, more employers will make this as an option. And, not to get into a discussion of the generational differences here, but I think that younger generation, millennials, and folks coming into the workplace are generally more comfortable with, sharing public information or not having that maybe the same expectation of privacy that the generation before did. So I think we'll see more of this coming down the pike. In light of that, let's ask a poll question. Can an employer, as a condition of employment, require an employee to use a fingerprint or biometric scan to track the number of hours worked? What do you think about that? we'll take a vote here, and then we'll go into some discussion of that Illinois law that I mentioned off the top. Again, pretty split. Half of you say yes, half of you say no. The answer, again, is it depends. Depends on the jurisdiction. I will say that the default answer, again, in a state where we don't have a law on point, is that the employer probably is allowed to have an employee, use his or her fingerprint to log in a time card setting. But here's an example of a state where you can't. Illinois has the Biometric Information Privacy Act, okay? And it entitles those who are in possession of biometric identifiers must develop a written policy with respect to the collection and the retention of that information, okay? What is a biometric identifier, right? It's fingerprints, facial scans, retina scans, voice prints. These are all biometric identifiers. And one of the reasons that these are particularly, sensitive is because if we're using Social Security numbers or some other login information and they get compromised, well, they can always be changed. But if I, as the employer, am storing a record of all my employees' fingerprints or retina scans and those get stolen, the employee can't go and change that, right? So the attitude is that, we're going to require employers to be much more careful about the way that they collect and use this information, okay? The text of the statute, again, says that if you're going to be collecting and using this information, you've got to have a written policy. It has to be available to the people, and you're fully disclosing what it's being used for. And then you also have to have a retention schedule that says, this is the reason we're retaining this information, and that we will destroy this information and get rid of it in a way that makes it impossible to be stolen or disclosed to a third party once our purpose for that information has been satisfied or within at least 3 years of the individual's last interaction with this entity. So there are all these sort of obligations that are placed on an employer who's using it in this context. Texas has a similar biometric privacy statute. It's not quite as expansive as Illinois' law, but it's the same sort of thing. And again, this is the direction the law is going. This is an area where I think even employers who are not, typically Big Brother, might be interested in adopting some of these things because it can be useful for not to have to issue employees ID cards or login information if you can just use your fingerprint. I use Touch ID on my iPhone, as I imagine many of you do. I find that incredibly useful to log into different apps and websites. Many employers have employees use their thumbprint to log into time clocks. One of the reasons they like that is it eliminates this concern of, what some people call buddy punching. If you have to use your fingerprint to punch into a clock, you're not going to be able to punch somebody else in. We have actually already seen, though, a recent class action by employees in Illinois who are saying, listen, an employer who's requiring me to use my fingerprint to punch in or punch out is subject to this Biometric Information Privacy Act. And unless that employer is following all of these procedures and has these pieces in place, they stand to be in violation of the statute. I am going to fast forward a little bit so we get to our last poll question. This is sort of a summary of something we touched on before, but the question, is an employer permitted to monitor employees' computer, internet, and cell phone usage without written consent from the employees? What do you think in light of what we covered already? Yes, that's the right answer. And it's tricky because I just got done telling you about how there's all these laws that say, in many instances you have to give employees all this advanced information and get that written consent. And again, that's our best practice. That's Laura and my recommendation to you in these instances to get that written consent. But in the absence of a specific statute on point, an employee typically does not have that expectation of privacy in most work settings. So the answer is that typically the employer has the right to do it. Again, that doesn't change sort of what I think our advice to you will be. So with that, I'll turn it back over to Laura to share some sort of key takeaways and recommendations here.
Absolutely. So first of all, again, like we've been talking about this entire presentation, we highly recommend that employers develop a clearly articulated policy that is communicated to employees. So very expressly delineate what it is you're monitoring, how you're going to be monitoring it, and quite frankly, it's best to say why that you're monitoring it. And you might not be required by law to tell employees why they're being monitored, but this goes to this employee morale issue. If employees are being told that there is a legitimate reason, like we are concerned about our confidential data or we have trade secrets that we don't want getting out, I think employees are much more accepting of those sorts of justifications as opposed to, well, we just want to make sure that you're not loafing on the job. And again, this should go without saying as well, but make sure when you are monitoring employees that you don't select a specific group of employees to monitor. We would not want employers to run into an issue where they are being alleged of monitoring only older employees or employees of a certain race or gender. Even if it's not intentional, if it's sort of shown this is happening, you could land yourself in a discrimination claim.
And to be clear, like Laura said, we don't want you to be picking a group that could be characterized as having a disparate impact on some protected category. So you might decide, I'm going to be monitoring production employees in a way that I'm not monitoring office employees. But what you don't want is, I'm going to be monitoring employees in this sort of subgroup who happen to be all women or happen to all belong to a minority class, for instance, because that's where you are going to run into that discrimination issue that she raises.
Exactly. And again, while this might not be required in all circumstances, legitimate needs are always good to set forth. And even if you don't inform your employees of the legitimate need to do so, you might want to have it in your back pocket just in case there is an issue and you need to justify to a court or other administrative agency why it is you were engaging in the actions you were. It's also advisable to use the least intrusive or least invasive means possible. If you can achieve your security goal by doing a very minimal action as opposed to having this video surveillance, audio surveillance, the belt and suspenders, it's more advisable to do the least amount of what you have to do to avoid tripping on any invasion of privacy claims. Like I mentioned, always be mindful that monitoring beyond the scope of what's actually necessary for the effective operation of your business can lead to invasion of privacy claims. Like I mentioned, if you're monitoring employees' GPS, even on their cell phones after work hours, you could learn something about those employees that the employer may unintentionally develop a bias against that employee, and again, could be the basis of a discrimination claim. And another issue is these device policies. I'm not going to go too much into this, but there are these device policies, BYODs, the bring your own device. That's where the employee provides his or her own cell phone, whatnot, and then the employer and uses it for business purposes. This is the least amount of cost to the employer, but employers have to be mindful of the fact that this can create concerns due to lack of control over the device, security issues, if they're logging into a bad Wi-Fi spot. And again, with these personal devices, employers should be very sure to expressly outline the monitoring policies so employees know how these personal items that are being used for business purposes are going to be monitored by an employee. The CYOD is a choose your own device. Employees can sort of choose from their own set of approved devices. They're paid by the employer and owned by the employee. Paid for and owned by the employee, but the employer can provide a stipend when the employee leaves or gets rid of the phone. And the corporate owned, personally enabled, that's the most costly for employers, but it also provides employers the greatest amount of control because the employer owns the phone and the employee just gets to use it. So this is beneficial, for example, if you are involved in litigation, you can put the litigation holds on all of these devices. You can monitor how they're being used and make sure that your data is being treated in a confidential manner.
Well, we have reached the end of our time. As I said at the top, we will be happy to take a look at any questions that you might submit, and Laura or I will follow up with you to see if there's anything we can help with. We really appreciate you joining us for our program today. We hope that the information provided was helpful for you and your organization. If you haven't done so already, please click the survey icon button at the bottom of your screen to complete our short survey. That helps us in providing quality future programs and improving our content. As a reminder, if you are in Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, or Wisconsin, this program has been approved for continuing legal education credit, and it's been approved by the HR Certification Institute and the Society for Human Resource Management for recertification credit. This webcast has been recorded. Laura and I will edit it to make sure it makes us sound as smart as possible, and it will be made available tomorrow for you to watch and share. Once that's available, a link to the recording is going to be emailed to you along with a certificate of attendance. The webinar has concluded. Thanks again for joining us.